Good evening to everyone present here. Welcome to the ninth and the last class of the course. Now I would like to call Miss Bhumi Agarwal ma'am for take over the session.
Yes, hi, good evening, class. So, today we'll be proceeding further with the intercreditor agreement and the share pledge agreement. So, before proceeding further with these two agreements, I want to know have you all attended the last class of the loan agreement? If there is anyone who wants me to repeat that class or wants to revise anything about that class, do let me know, because you will understand intercreditor agreement only if you have knowledge about what loan agreements are.
No, I have not attended.
Okay. Is there anyone else who wants me to repeat that class? No, ma'am, I haven't attended this. Yes. Okay. Okay. Just give me a second. I'll quickly go through that loan agreement and then we can proceed further with the intercreditor agreement. Is my screen visible? Yes, class.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Okay. So I guess you all have a idea what loan agreements are, right? It is basically a contract between a lender and a borrower where borrower borrows money from the lender for a particular consideration and for a particular time period. Okay. The loan agreement is a contract between a lender and a borrower under which the lender makes available loan, which is money stand for monies. I guess last time किसी ने पूछा था मुझसे. So I'm clarifying this. Loan monies to the borrower. In essence, loan agreement provides the contractual basis under which the loan is made. Okay, so basically loan agreements are of two types: unsecured and secured. Unsecured loan agreements are the loan agreements in which we do not give any kind of security in return of the loan amount advanced by the lender. And in the secured loans, we give something as a security to the lender against the loan amount which we are receiving from them. That security can be anything. It can be shares, it can be any property, it can be gold, it can be jewelry, anything. Okay, anything which has a value equivalent or more than the loan amount granted. The major difference that is between a secured loan and unsecured loan is that the secured loan is attached, which ensures that the recovery of loan upon the failure by the borrower to repay. However, unsecured loan hai, in that the lender cannot attach a property of the borrower for the recovery of loan. Okay. Any doubt in the basic? What is loan agreement? No, ma'am. Okay. Proceeding further. This is the draft. I guess I've shared this draft with Paras and he must have shared it on the group. So this is a single bank loan agreement draft wherein a company has borrowed money from the other company, which is the lender over here. I am not going into clause by clause. You can see the recording for that. I'll just discuss the basics and then we'll move on to the intercreditor agreement. This loan agreement this is simply the introductory clause and then coming on to the boilerplate clause so that you can understand what is the basic crux of this agreement. A borrower is a businessman who is in the business of construction and development of real estate, commercial and residential. Okay, the borrower wishes to construct a housing society situated at so and so place. So this is the purpose of this loan. He wants to construct a housing society for which he requires fund, which he is taking as a loan from the lender. Pursuant to mutual discussions, the lender has agreed to grant the borrower the loan of rupees so and so towards the purpose, which we have already discussed, towards the purpose, and the borrower agrees to use the loan on the terms and conditions as set forth herein. Okay, now comes the definition clause. You can go through it. Interpretation, nothing major. Then comes conditions and purpose. Subject to the lender having received and found satisfactory, the borrower shall provide relevant documents and comply with the conditions prior to drawing the loan. Now here, the borrower is saying that I will provide each and every document which is relevant and which will be required by the lender for the lending of loan, and these all conditions will be fulfilled prior to the grant of loan. A copy of resolution. So this is here, this is a company. The borrower is a company. So if a company is taking loan in his name or in its name, then of course there has to be a particular authorized person who is signing on behalf of the company, and whoever sign as the authorized agent of the company requires a board resolution from the company. So this particular clause is talking about that before entering into this loan agreement, the borrower is obligated to submit all the required documents, which is inclusive of the copy of resolution of the directors of the company, having certified him as the authorized signatory of the borrower. Okay, a copy of the resolution of the directors of the borrower certified by the authorized signatory of the borrower to be in full force and effect at the receipt of the lender, approving his agreement and authorizing a person or persons to sign and deliver on behalf of the borrower this agreement and the security document. Now coming on to the comment, this clause signifies the requirement of copy of board resolution of the directors certified by this authorized signatory of the borrower to be in full force and effect at the date of receipt by the lender. This is required when a borrower is a company which needs to procure a loan. This is what exactly I have told you guys right now, that whenever a company is borrowing any money from any particular firm or any particular company or lender or institution, that company has to submit its board resolution or authorizing a particular person to sign as a authorized signatory or to act on its behalf. A guarantee from the guarantor. Now if there is a guarantor, then of course there has to be a guarantee, and there is a different form and format, a different small agreement for that guarantee, which has to be filled in by the guarantor. Okay, a copy of memorandum of article and memorandum of association of the borrower certified by the authorized signatory. Then the security documents. Now because here a company is taking loan for the construction of a housing society, so of course this loan amount will not be a very small loan amount, it will be a big loan amount. And in such cases, when there is a loan for the purpose of any construction or real estate business, it is always advisable to have a secured loan. So in this case also we are discussing a secured loan, so we will be executing the security documents also in order to secure the loan amount. A borrower shall be entitled to draw and the lender shall advance the loan in full. So here this means that a company that the lender is advancing the loan amount in full. Now it's upon the borrower either to draw that entitled loan amount in full in one day or in parts or in years as he wish. Okay, now let's see this example. Suppose XYZ is a borrower, is taking loan of rupees 10 crores for the development of a housing society in so and so place. Lender will pay this amount to XYZ company on the date of entering into this agreement in full. Suppose XYZ is having its account in Bank of India. Okay, so on the date of entering into this agreement, or suppose having its account in Bank of Baroda. So on the date of execution of this agreement, the lender will transfer rupees 10 crores to the particular bank account of the XYZ. Okay, but it is upon the XYZ to use it either complete rupees 10 crore in one go or to use it in parts. Okay, according to this clause, the lender shall advance the loan amount in full. The borrower has the right to draw from the loan amount as per its requirement. This withdrawal can be recurring in nature. Recurring means it can be in a short durations as per his convenience and as per the borrower's requirement. Any doubt till here? Guys, this is the last class. If you have any doubts, keep on asking.
No, ma'am.
Okay. The lender will, in consideration of the borrower agreeing to repay the loan on the terms of this agreement, advance up a amount of rupees itna in full to the borrower in respect of the borrower's specified and agreed purpose. The loan shall not be used for any other purpose by the borrower without the prior consent of the lender. Now, this clause is very important. Suppose a loan, here the loan is being granted for the purpose of construction of housing society. So, the borrower is under an obligation to use this money only for the purpose of that construction of housing society. He cannot use it for any other purpose, especially for any illegal purpose or personal purposes. Okay, if in case he does so, then the lender has full authority to seize the money, to seize his to seize the further withdrawal of money from the account it has been transferred. Now let's see the comment clause to understand. This is a key clause with respect to the application of money advanced through loan to the borrower. The borrower can only use this loan with respect to the purpose for which it was initially subscribed for. For example, if a borrower is availing a loan for the construction of housing society, then the company is mandated to use the loan amount only with respect to the construction of the housing society and for such services in connection with. Okay, however, if a borrower chooses to use this loan money for alternative use, then the lender might either block the loan amount for further withdrawals and demand repayment of the drawn amount either immediately or within so and so days after default, or charge penalties and issue a notice of compliance to the terms and conditions. Now, if in case he uses this money for any other purposes apart from what has been agreed in the purpose clause, then the lender may even block his amount or demand the repayment of the loan amount which has already been withdrawn, or can even charge penalties depending upon the discretion of the lender. Now, coming on to the repayment of the loan amount. The borrower shall repay the loan amount together with indebtedness without deduction or set off or first to occur of the default. This clause is subject to variation depending upon the discretion of the contracting parties. Now, here this clause tells about how the repayment will occur. Okay. Now repayment can be subjective to what the lender wants. It can be either in part, it can be either in full. It can either start from 5 years later, it can either start from 10 years later, depending upon what the parties want. Suppose in this case, XYZ has taken 10 crore for the period of 10 years and he wants to prepay 5 crores before the date of repayment. Then in that case, XYZ cannot come later and ask for reborrow of this loan amount prepaid. Now, what is this particular example saying? Suppose the repayment date starts from, this is 2024. In 2024, XYZ has taken loan for the period of 10 years. Now, in the loan agreement, they have agreed that the loan amount shall be repaid from so and so day of the year 2034. Okay. Now, if in case this is the repayment period, which will start from 2034. But if in case somewhere in between 2028 or 2029, XYZ feels that I am having sufficient funds to repay now, so XYZ can come ask if there is a prepayment clause. XYZ can come ask the lender and start the prepayment of the loan amount along with the interest even from 2029 onwards. But if in case he prepays rupees 5 crores, suppose XYZ prepays rupees 5 crores in the year or by the year 2032. Okay. So he cannot later in 2034 come, I'm just giving the example, come and ask the lender to reborrow come to the lender and reborrow that 5 crores which he has already prepaid. Understood? Any doubt in this? Any doubt, anyone?
No, ma'am.
Okay. Let's go through the comment clause. This clause specifies that repayment or prepayment of a loan amount in a form of monthly, quarterly, half-yearly, yearly installments is not subject to reborrowing of the said amount. In addition to the payment guidelines mentioned in this agreement, a subsequent clause regarding cleanup could be added. A cleanup clause is a contractual provision which specifies that a borrower, upon the repayment of loan within a stipulated period of time, would not be entitled to made available for the another loan for a period of so and so days. This is exactly what I have explained here with an example. Then comes how the interest will be calculated and how the default interest will be calculated, which is an interest upon the interest. The principal amount of loan outstanding shall carry an interest at the rate of so and so % per annum above the base rate, as varied from time to time of the lender, accruing daily and payable in arrears upon the repayment of the loan. This is a simple interest clause. Then coming, interest at the rate of so and so above the base rate of the lender from time to time shall accrue from the repayment date on the loan compounded monthly on the last day of each month and calculated both before and after the demand or judgment on a daily basis and the yearly basis. On the repayment of the loan in accordance with so and so clause, all accrued interest shall be paid unless otherwise agreed. For the avoidance of any doubt, any sum paid to the lender shall be applied firstly in settlement of the principal sum due, secondly in the settlement of the interest due under this agreement, and thirdly in the prepayment of other sums due under this agreement. Notwithstanding anything to the contrary, the lender shall be entitled to defer or waive off any or all payment of interest on the loan by the company pursuant to this agreement. So now what is this clause saying? That interest rate of so and so percent per annum will be charged on the principal amount, and any amount which XYZ is giving to the lender, he will first adjust it to the principal amount. The principal amount here is 10 crores. Okay. Supposedly it is 10 crores is the principal amount. So whatever is the lender giving, it will first be adjusted towards the principal amount. Then suppose there is so and so percent of interest, which may come to, again, suppose 50 lakhs. Then secondly, it will be adjusted towards the interest amount, and then remaining will be adjusted. If he is giving any other payments, then that will be regarded as the prepayment towards the remaining loan amount which is there. Any doubt? Moving further. Here is the prepayment and the security clause. The borrower may prepay the whole or any part of the loan at any time. I have already discussed what prepayment is. That any payment of the loan amount before the agreed date of repayment is called prepayment. Okay. So it is very subjective and it is upon the discretion of the lender to either allow prepayment or to completely restrict the borrower from any kind of prepayment. Why do the borrowers restrict any kind of prepayment in several cases? Because suppose someone is taking money from you today, and what you are earning by giving him money is the interest. The longer will be the repayment date, the more money, the more revenue you will generate from that loan. So a lender is generating its revenue from the time period, the time gap between the loan amount granted and the repayment date. If someone comes in between and repays the loan amount earlier to the agreed date, then that will of course affect the remuneration that is being generated by the lender. So there are several cases where lenders completely restricts the borrower from any kind of repayment, and upon the non-compliance they may also impose penalty. So this particular comment clause is explaining that only. The repayment of loan and indebtedness will be secured by way of fixed or floating charge over the assets of the borrower as specified in the security documents. Now here, if someone fails to repay upon the particular repayment date or upon the date which the lender has agreed to further to the repayment date, then in that case, the lender is free to use the security documents and to recover the loan by the security which has been submitted by the borrower. Okay. Then comes the representations and warranties clause, which is very simple. You can just go through it once and let me know if there is any doubt. Then undertakings. Then comes the event of default, another important clause. What can be the events of default? The lender shall be entitled at any time after the occurrence of any event of default by notice in writing to the borrower to declare that indebtedness has become immediately due and payable, and the borrower shall immediately pay the same to the lender. In an event of default occurs if the borrower suffers a change in control without the prior consent of the lender, or if subject to any trade sale, flotation, or refinancing, and change in control means any event in which either. So now this clause is speaking about the event of default. When there will be an event of default, there will be an event of default in case the borrower here in this case is a company. So if is any change in the control of company, which is when there is a when there is a change in control of the company, it occurs on two occasions. First, if more than 51% of the voting power of the borrower is now vested with some other company, or there is any change in the voting rights of the company. Then in those two events, if the company has made such changes in its voting rights or in the voting power without the information being given to the lender, this will amount to an event of default. And in the event of default, or there is any winding up proceedings against the company or any such, all these, you can just go through these clauses once. Event of default, all those who have not attended the last class can just go through these clauses and let me know if there is any doubt. Should I proceed further?
Yes, ma'am.
Okay. So now next clause is fees and expenses. Whatever fees will be there in the execution of these documents and in the execution of the security documents which the borrower will submit as a security, all those expenses will be bared by the borrower. This clause simply says that. Then is the currency and payments. All the payments will be done in the currency where the agreement is made. Suppose the agreement is being entered in India, then of course it will be, all the transaction will be in rupees. If the agreement is taking place in US, then maybe it will be in dollars. Okay, so and so. So this was all about the loan agreement. I hope you have the basics clear now. Further, we'll discuss about the intercreditor agreement. Is there any doubt in the loan agreement? I'm not going through clause by clause because that will again take 1 more hour and we need to finish this up today. So you can just go through the recording.
No doubts, ma'am.
Okay. Now, today we will be discussing about another agreement, which is the intercreditor agreement. Now, according to the Corporate Finance Institute, an intercreditor agreement is a legal document established between two and more creditors. This agreement outlines in advance how their competing interest will be managed and how they will collaborate to support their mutual borrower. Typically, this agreement involves two kinds of creditors. One is a senior lender with authoritative rights, and thereafter is a subordinate junior lender. However, situations may arise where multiple senior lenders are involved, necessitating an additional agreement among them. An intercreditor agreement specifies the terms and distribution of the collateral among the common lenders if the borrower defaults. This arrangement is beneficial as it safeguards the right of the subordinate lenders. The agreement delineates a borrower's right and obligations concerning collateral, payment priorities, and hierarchy among creditors. Although intercreditor agreements have gained prominence recently, there is still limited case law on the interpretation. So now, what exactly is intercreditor agreement? It is an agreement between various lenders and their mutual borrower. What we have discussed now in the loan agreement, there was one lender and one borrower, right? But here in intercreditor agreement, there are several creditors who are crediting their money as a loan to one borrower, to a mutual borrower. And this agreement over here governs how they will compute the interest and how they will compete their interest and manage the repayment and other securities. Okay, understood?
Yes, ma'am.
Okay. Now give me an example if you have understood. Who said yes, ma'am? किसने बोला था yes, ma'am? Vaishnavi, was it you? Just give me an example. Unmute yourself and give me an example. Any example, layman example. Yes, class. I'll not proceed further. Just give me an example. Whoever said yes, ma'am. Okay. I'll I'll give you an example. Okay. Consider an example where company A enters into a contract with the government. Someone dropped a message. Paras. Okay. Agreement, for example, between SBI and PNB for advancing a loan to a common borrower, say, for example, XYZ, a big corporate. Yes, kind of. Correct. Good parts. Now, let me go through the example. Suppose a company A enters into a contract with the government agency to develop housing for armed forces personnel. The project's estimated cost is $125 million, with company A contributing rupees 25 million, $25 million. To cover the remaining cost, company A seeks additional funding from the government and other financiers. Company A uses valuable assets to secure funding from both government agency and third-party financiers. In this scenario, government agency B would act as a junior lender, the third-party financiers as senior lenders, and company A as the borrower. To protect their interest, third party financiers would likely require an intercreditor agreement. Understood? Here, company A is entering into a contract with B and requires a fund of $125 million, which is a very huge sum. Now, company A has only $25 million to contribute in this project. For the remaining, it will seek help from the other financiers and the government agency. Now, here the government agency is lending a particular sum, and others, suppose there is $25 million requirement. So, suppose government agency is lending $5 million, and for the remaining $20 million, it is approaching third party financiers. So now here the government agency will act as a junior lender and the third party financiers will be acting as a senior lenders. Okay, and to govern this mutual understanding, they will require an intercreditor agreement. Let's understand with one another example, which involves XYZ planning to raise $100 million. A bank agrees to provide 20 millions, leaving behind 80 millions to be sourced from external creditors. The first external creditor agrees to contribute 50 million, while the another commits 30 millions. In the event of the borrower default, an intercreditor agreement between the two external creditor will clarify which lender has the first claim on the borrower's assets and how much each lender can recover. This agreement eliminates any kind of confusion and ensures a clear understanding among the lenders regarding their recovery and right of the amounts. Okay, now here XYZ is a company which is planning to perform certain project for which it requires $100 million. Okay. Now it is taking these $100 million from several different external creditors. A bank is crediting 20 millions. There is another bank, another financier who has agreed to credit 50 million, and the another who has agreed to commit 30 millions. Now, suppose XYZ fails to give the money. Who will come into the picture first? How will the security which company has given to all these lenders mutually will come into the picture? Who will first come and recover the money? All this will be governed by the intercreditor agreement. Okay. Is one last example. Suppose there is a startup tech company. Okay. Now Tech Innovators, named as Tech Innovators Incorporation, seeking 50 millions to develop a new software platform. Now Tech Innovators secures 10 millions from the venture capital firm acting as a junior lender and needs to raise the remaining 40 millions from the external investors, which are the senior lenders. To protect their investments, the senior lenders would require an intercreditor agreement with the venture capital firm. This agreement would specify that in case of any default, the senior lenders have the priority in claiming the company's assets and recovering their funds before the junior lender. Okay, clear? Any doubt in this? Any doubt? Should I proceed further with the drafting? Yes, class. Okay.
Guys, please respond. Vaishnavi, Bhavya, Siali, Latnesh.
Now this is intercreditor agreement. This intercreditor agreement, known as agreement hereinafter, is being entered on so and so date, which is the execution date at so and so place among the following parties. Now, before going into the parties, let's understand what is this agreement about by going into the recital clause. Whereas a Centin Private Limited, which is the borrower, is a private company incorporated under the Companies Act 2013 and deals in building, planning, and manufacturing of various government projects. It has contracted with the Government of India to construct the housing development plan for army veterans. In order to raise the funds from this project, the borrower required a loan amounting to rupees 100 crores. The lenders are various financial institutions incorporated as per the regulations of India and involved in various financial services like funding, granting loans, etc. To obtain this loan from the borrower, to obtain this loan, the borrower has approached the lenders and the lenders have granted the borrower a loan amounting to INR 100 crores, which is the loan amount herein, cumulatively as per the syndicate loan agreement dated so and so, hereinafter known as the loan agreement at place so and so among the borrowers and lenders. In pursuance of this loan agreement, the borrower has given high value assets as security against the loan amount in favor of the lenders collectively. The lenders, to record their obligations and rights, have mutually agreed to enter into this agreement to avoid any further ambiguities in relation to their syndicate relationship as per the terms of this agreement and the loan agreement. So now this is not a loan agreement, okay? This is an intercreditor agreement which will govern how the relationship between the different lenders will be governed, okay? This is not a clause which is saying so and so lender is giving so and so money to the borrower. That is in a different loan agreement, okay? Now, in pursuance or in continuance of that loan agreement, they are entering into the intercreditor agreement in order to ensure that there is no conflict in future in relation to the security assets or the repayment of loan later at any point of time between the different lenders. Okay, this is what is the recital clause saying. Understood? This is a bit tricky agreement. If you guys have any doubt, please ask me. Otherwise, you will not get what this agreement is all about. Okay. Now going on to the introductory clause. These are the following parties: Government of India, a financial institution incorporated as per so and so, having its financial body at so and so, authorized representation by so and so, known as lender 1. Then there is Canara Bank, a financial institution incorporated so and so as known as the lender 2. Then there is State Bank of India known as lender 3, and then there is Karnataka Bank known as the lead bank. Now why it is known as the lead bank, we'll discuss further. Hereinafter in this agreement, lender 1, lender 2, lender 3 and the lead bank are collectively referred to as the lenders. Now the lenders hereby mutually agree to as follows. If you see here, it says lenders hereby mutually agree. So this intercreditor agreement is basically between the lenders so that they do not have any doubt or any dispute later at any point of time regarding the repayment of the loan amount which they have agreed via a separate loan agreement, which is a syndicate loan agreement. The lenders hereby mutually agree that they shall abide by the terms and obligations of this agreement and that they are equally bound by this agreement. The lender shall fulfill all its role and responsibilities in relation to this agreement. The lenders hereby agree to appoint Karnataka Bank as the lead bank to take the decisions and to implement various provisions of this agreement to recover the loan amount along with the applicable interest on the non-repayment of the same by the borrower within the repayment date defined in clause so and so as per the terms of the loan agreement. Such event of non-repayment is hereinafter referred to as the event of default. Now, why is a Karnataka Bank known as the lead bank? Because this is the particular bank which will take all the decisions regarding the implementation of this agreement. How there will be a recovery of the loan amount in case of non-repayment, which is known as the event of default. When there is a particular event of default, then how there will be how the repayment will take place in such an event. Just give me a second. Yes, sorry. So in case there is any non-repayment by the borrower, which will amount to an event of default, then how that will take place, how the repayment will take place, or how they will use the security which has been taken by the borrower for the repayment of the loan amount, all these decisions will be taken up by the Karnataka Bank. That is the reason why it is known as the lead bank. Now coming on to the next clause, in case of the occurrence of event of default by the borrower, the lead bank shall take the necessary steps to recover the unpaid loan amount along with the applicable interest as per the loan agreement. Such steps shall be taken only and when agreed by the majority of lenders. So now, how will the steps be taken in order to recover this unpaid loan amount? All this has been already incorporated under the loan agreement which they have entered into. Okay, but all these decisions will only be taken when there is a mutual decision by the majority of lenders. Suppose there are 4 lenders over here in this case, then there has to be a mutual agreement between at least three of the lenders in order to continue with the steps which lead bank is proposing. Okay, the lead bank shall be responsible to access the debts and rights of each of the lenders under the loan agreement and this agreement. Lead bank will also have the responsibility to access all the debts and all the rights which each of the lender has under the loan agreement. The lead bank shall be responsible to send notices to the borrower in case of any default or to notify it regarding any information related to this agreement and the loan agreement. Okay, so now here the lead bank is also responsible to send notices to the borrower in case of default. Who, of course, not all the banks will start sending the notices. There is one bank who is taking charge of everything, taking charge of sending notices, taking charge of making a roadmap of how the money will be recovered in case of event of default. And over here all this charge has been taken up by the lead bank, which is the Karnataka Bank. The lead bank shall be responsible to record the transactions being done in common amount generated as per clause so and so of the loan agreement. So whatever loan agreement they have already entered into must be having a clause which will enumerate of what the common loan account will be there of the borrower, where each of the lenders will make the transactions into. Now this is the lead bank's responsibility to record how these transactions are being taken place and how the borrower is drawing the money from that common account at when and at what durations and for what purposes. Okay, the lead bank shall be responsible to notify and conduct meetings among the lenders as and when required. Any doubt in this clause? This is the most important clause of this entire agreement, which depicts the responsibilities of the lead bank and who will be functioning as the lead bank, who will how many responsibilities will be there on the lead bank, and what all obligations are there on the lead bank, and who will look into the transactions and everything. Any doubt in this class? Okay, proceeding further. Now the amount of loan and interest. This particular thing will also be there in the loan agreement, but in order to clarify, we are including this here also in this loan agreement, in this integrator agreement. Amount of loan and interest. The lenders have, by mutual consent, granted the borrower a loan of INR 100 crores, which is the loan amount, collectively as per the terms of the loan agreement, and this loan amount shall be repaid by the borrower to the lenders by 31st of March 2035, which is the repayment date. Each lender has granted the loan amount in the following manner. Now the lead bank has granted 35 crores. Lender 1 has granted 30 crores. Lender 2 has granted 25 crores. And lender 3 has granted 10 crores. Now interest imposed by all these banks is equivalent, which is 12%. Okay. Now here, if you can see, why is Karnataka Bank a lead bank? Because Karnataka Bank is the bank which has granted the majority amount of loan, the maximum amount of loan to the borrower. The borrower has given the security against the loan amount in favor of the lenders as per the terms of the loan agreement. In case of event of default, the lender shall be liable to charge an interest rate of 18% per annum, which is the default interest on the loan amount till the date of complete recovery of this loan amount, along with the applicable interest as per the terms of the loan agreement. So now this default interest is the interest upon interest. Suppose the repayment date is 2035. Okay. Now there is a default on the part of the borrower to repay the loan amount, to repay the principal amount due, or the interest due in 2030. Okay, so now this, because this is a huge loan amount, this will be in part payments. Okay, so suppose it's starting from 2030 till 35. Okay, these are the 5 years given for the entire repayment of loan, and in January or in March 2030, the borrower defaults in making the payment of the principal amount due for that particular month, along with the interest, which is equivalent to 12%. Okay, then in that case, the borrower shall be liable to pay an additional interest of 18% per annum. This is an additional interest upon the interest and the principal amount. Any doubt in this? Any doubt, class? Should I proceed further? Okay. Now coming on to the reps and warranties, the lender hereby represents and warrants that each lender has the capacity and right to enter into this agreement. Each lender is incorporated under the Companies Act so and so and other laws and regulations of India as per their nature of working. Each lender is in financial position to grant this loan amount to the borrower. Each lender has complete and sole right over the amount given as loan. No third party claims, rights, or encumbrances are attached to the loan amount granted. All the documents submitted by them are true and legal. No criminal or civil proceedings are pending against any of them. Each lender has taken all the necessary approvals from the competent authority for taking all the decisions for the purpose of this agreement. Each lender has authorized the lead lender to take all the actions that are contemplated under this agreement. This is the important reps and warranties under this. Each lender shall provide all the informations to the other lenders in relation to this agreement. Each lender has complete intent to fulfill the obligations laid under this agreement. Any of the lender will not resort to any fraudulent ways to recover the loan amount. Now, lead bank has a different representations and warranties over here because it has the majority role in this agreement and the majority of the responsibilities under this agreement. So now the lead bank hereby represents and warrants that it shall act in accordance with the terms of this agreement and to complete the purpose of this agreement. It shall not create any personal interest or act in a biased manner to favor any particular lender. It shall remain fair and impartial to the agreement and the lenders herein. This is simple. If you want to discuss anything, please drop in the text box. I'll discuss that. Now coming on to the next clause, which is the resolution plan. In case of occurrence of an event of default on the part of the borrower, the lender shall be entitled to the following rights. First is right to recover the loan amount and the applicable interest along with the default interest, which we have just now discussed, form the repayment date till the one is fully recovered. Second is right to sell the security in case the borrower fails to repay the loan amount by giving a notice of so and so days prior to the execution of such right. Third is the right to extend the repayment date. Fourth is the right to approach the authorized authorities in case the borrower is declared insolvent by the competent court. Then fifth is right to demand further securities or cash in case the amount of security does not satisfy the value of loan amount along with the applicable interest. Then comes the right to categorize the debts payable and write off any portions of the loan amount or interest due on behalf of the borrower. Then the right to waive off any default on the part of borrower for a certain time period as may be decided. So this is the resolution plan, and these can be the following events of occurrence in case there is any default on the part of the borrower. Either they can recover the loan or they can sell the security.
1,50,000 ಅವೇ ಮನೆಗೆ ಮಾಡ್ತಾನೆ ನೀನು ಮನೆಗೆ ಮಾಡ್ತಿ ಈಗ ನೀ ಹೈರಾಣ ಹತ್ತಿ ಮಾಡ್ಬೇಡ ಹಾಕ್ಬಿಡ ಮಾಡ
Okay, proceeding further. Either they can recover the loan or they can sell the security or they can approach the authorized authorities in case the borrower is declared insolvent, or they can demand further securities in case the security amount becomes lesser than the loan amount along with the interest due, or they can waive off any default on the part of borrower if they mutually agree to do so. Any doubt in this? Okay, proceeding further. The lender shall mutually exercise the rights given above in the following manner. Now, this is the mannerism in which these rights will be executed. The lender shall hold a meeting by mutually deciding the time and place and shall discuss the steps to be taken to recover the loan amount. Now, suppose they have mutually agreed to sell the security which has been given by the borrower as a security against the loan amount taken. Okay, so now in order to sell the security, they will first hold a meeting by mutually deciding the time and place and shall then discuss what will be the plan of action and how this security will be sold out or how they will recover the loan amount in any other alternative manner. Such resolution plan shall be executed in the manner as decided by the majority of lenders. Each lender shall be given equal right to vote in the decision-making process to approve the resolution plan. Each lender shall give their vote, keeping in mind that the resolution plan will be executed for the benefit of all and shall not be in any biased manner. The lender shall take steps of the resolution plan in accordance with the terms of the loan agreement. In the event the lenders are unable to decide upon the resolution plan, they can mutually appoint a neutral third party who will oversee the process and will contribute towards the voting. If any of the lenders do not wish to continue with the approved resolution plan, they can recover their contribution towards the loan agreement as decided by the lenders and exit the process of the resolution of the borrower. Okay, any doubt in this? This mannerism only says that they will hold a meeting at a particular place and time and will decide the course of action. This resolution will be executed what will be decided by the majority of lenders. As have already been discussed, each lender will have a particular voting right and each member will be given equal voting rights, and whoever wins by the majority that that those lenders will have the majority stake and say in the resolution plan, and will accordingly decide that okay, this will be the course of action we will follow in order to get the loan amount back from the borrower. Okay, if in case any of the lenders disagree with the resolution plan, then of course there is always an option to appoint a neutral party who will oversee the entire process, but that will again be by the voting of the lenders. Then comes severability clause. If any clause of this agreement is held to be invalid by the court of competent jurisdiction, then in such case the invalidity of any clause shall not affect the validity or operation of any other clauses. Such provision of clause shall be deemed to be severed from this agreement. So this clause simply says that if in case by any law or by any court a particular clause under this agreement is held invalid, then that will not amount or that will not make the entire agreement invalid, but only that particular clause will be severed from the entire agreement and will be changed. Then comes notices. Any notice required to be given provided under this agreement shall be given to each lender personally by the lead bank and vice versa by speed post or an email or both. So here the responsibility of giving and taking of the notices is via lead bank. If there is any notice which has to be given to the lenders, it will be via lead bank, and if there is any notice which has to be given to the other lenders, then also that will be via lead banks on so and so addresses and email IDs. In case any of the lenders changes the above given details, then the same shall be notified in writing to the other lenders along with the new details within a week of so and so via speed post or an email. Thereafter comes another important clause, which is assignment. Neither of the lenders is allowed to assign the agreement or the rights or obligations to any third party or parties without the prior express written approval of the other lender. Now, none of the lenders here has the right to transfer or alienate or assign their rights and duties under this agreement to any third party unless and until there is a prior written express approval from the other lenders. Then comes modification. This agreement may be modified or amended in whole or in part at any time during the validity of this agreement or by any other agreement in writing and executed mutually by the other lenders to this agreement. Simple, nothing to explain. Then comes set off. The lender shall be entitled to set off any of the debts due to them against the deposits held with them in the name of the borrower. Now here each of the lender has this right and is entitled to set off any of the debt which is due with them against what has been deposited with them by the borrower. Then the counterparts, this agreement may be executed in so and so counterparts, and each of the counterparts shall together constitute one agreement. Any lender may enter into this agreement by signing any such counterpart. So this counterpart is a part of boilerplate clauses. This says that the agreement may have n number of counterparts, but all that counterparts, if have been signed by the lenders, then will form a part of this agreement and will be read together with this agreement. So these are few of the important clauses of intercreditor agreement. Any doubt in this intercreditor agreement? Can, by way of agreement, lenders can override the provisions and procedures of IBC as far as resolution plan is concerned, which needs the approval of NCLT. Far as here the resolution plan we are talking about is not the one which is submitted with the NCLT. That's completely a different case. We submit a resolution plan over there. Over there, the resolution plan is firstly submitted by the COC, Committee of Creditors. They are not a committee of creditors over here. There are few creditors. Now, suppose the borrowers goes under insolvency. Okay. Now, in that case, but COC is of financial creditors. Right? You are right. That is what I'm explaining. Suppose borrower goes under an insolvency, okay? Section 9 or Section 7 proceedings are initiated against the borrower. Thereafter, a public notice will be issued by the NCLT, by the give me a second. I'll explain with an example over here. Now, what happens under IBC? Suppose XYZ company, okay, someone which may be, suppose, bank A has filed a petition under section 7 of IBC, okay. This petition is allowed by the NCLT, okay. Now a notice will be issued, which is a public notice by the IRP, okay. Now, once this petition is allowed by NCLT, immediately an IRP is appointed, okay. Now, once this notice is issued by the IRP, this notice calls upon all the creditors to come and submit their claims against XYZ company. Okay, now here in this case, XYZ has taken loan of 100 crores from the lenders cumulatively. But these are just four of these lenders are just four of the financial creditors. But there may be n number of other creditors as well who may have given money to XYZ company in one or the other manner. Suppose XYZ is a builder. Okay. So now XYZ must be developing a project, n number of flats. It must have taken X amount from n number of allottees. Okay. So all those allottees will also submit their claims with the IRP and will also become the creditor. And once all these claims come and once a chart has been prepared of all the creditors, then the majority of creditors form the COC and submit a resolution plan. Getting my point? My point is the relevance in of terms in the intercreditor agreement as far as the resolution plan is concerned, as its approval is not in their hand, as there would be other financial creditors. Paris, can you just unmute yourself and ask these questions? It's not clear what you're asking, not getting.
Hello, am I audible?
Yes, Paris.
Yeah, my question is that what is the relevance of these clauses when their approval is not in their hand as far as the resolution plan is concerned? When the resolution plan is with the NCLT or it is finally with the COC and its approval has to be from the
That is
NCLT,
what I'm
then the
explaining, that this resolution plan, the term resolution plan over here used in this intercreditor agreement is not a par with what we discussed in IBC. Okay, here we are discussing about something very different from IBC. We are not
so
saying that the
whatever.
company has gone under insolvency. Resolution plan under NCLT will come into the picture only if the company has gone under insolvency. Here we are not saying that the company has gone under insolvency. There can be X number of reasons why the company has not paid, why the borrower has not paid an amount to the lenders. Okay, so in that case, how to recover the loan amount from the how the lenders will recover the loan amount from the borrower will depend upon the resolution plan which they mutually agree upon. That will not
This
have
is this
any.
is this is this is my
Yes.
point, that once the resolution plan terms have been settled in their agreement, in this inter-creditor agreement, and finally, if the resolution plan is being approved by NCLT, those two plans would be different.
Yes,
So, what is the
exactly.
relevance of these terms? Because
Not
they haven't mentioned it, nothing was mentioned in these terms as far as its final approval with the NCLT is concerned. They have just mutually agreed to something which is not in their hands.
who is saying. So you are getting into a completely different picture. Here, if you see, event of default does not says that the event of default will occur only in case the company has gone under insolvency. Okay, I'm giving an example. Suppose XYZ company, for any of the reasons, has defaulted in the payment of principal amount, okay, on the repayment date, but it is solvent. Now a company becomes insolvent only if it does not have the funds to give money to all its creditors. One of the creditor cannot come and say that the company has not paid me when the company is completely entirely a solvent company as per its books of account. Okay, for XYZ reasons, suppose XYZ company has a dispute with lenders. Okay, that dispute can be on the terms of the loan agreement, and so XYZ has decided that I will not repay the money to this company, to the lenders, okay, or to the particular bank, which is Canara Bank. Suppose XYZ company is saying that I have a dispute with Canara Bank and I am not going to pay money back to the Canara Bank. Then how will Canara Bank get its money back from XYZ company? It will then call for a meeting because they have mutually given the loan. So they will call for a meeting, they will sit, they will decide, okay, we can do one thing. We have a security, we have a particular property of XYZ which is in Delhi, which has been given to us as a security. So now if XYZ has defaulted in the payment, I am going to do one thing. I will mortgage that property and will recover my loan amount. So this will be their course of action in the resolution plan which has been agreed. The term resolution plan here is not the one which we use in IBC. Here it means a mutual plan, a mutual understanding, a mutual agreement between these particular four lenders to do a particular thing in order to recover their loan amount from XYZ company. It has nothing to do with the plan which is being submitted by the IRP, Resolution Professional, under the NCLT. If a company goes under insolvency, then of course this resolution plan will have no value and the money will be given to these lenders as per the resolution plan, as will be decided by the COC with the further consent of the NCLT. In that case, if that case comes into picture that XYZ has defaulted the money of all the creditors and has gone under an insolvency. Getting my point? Any doubt? If you still have the doubt, I can still further elaborate and explain to you.
Ma'am, can you explain financial creditors and other kind of creditors?
Yes. So basically, under IBC, there are two types of creditors. One comes under the term known as financial creditors. And the others are the operational creditors. So now financial creditors are the people who have given money to a particular company or a corporate person in exchange of consideration. And operational creditors are the people who have given their assets, okay, or any other valuable property, material, or anything apart from money, or have in any way contributed to that particular company or a corporate person. Now I'll explain you with an example. Suppose Tata is the company, okay? Now in Tata, there are 1,000 employees. So if in case Tata fails to give its employees who are working as their operation team their salary, then all these people will come under the operational creditors of Tata. But if Tata has taken loan from SBI of rupees so and so amount, then in that case SBI will be termed as the financial creditors. So now under IBC, if the financial creditor wants to file an insolvency petition against a company, it has to file under section 7 of IBC. And if an operational creditor wants to file a petition against a company for insolvency, then it has to file under section 9 of IBC. Understood?
Okay.
Whoever working for the operations or whoever is giving, suppose there is a project which is being taken up by the Tata and there is other company who is giving cement and other raw materials for Tata to build up that project, then that particular company who is giving its raw materials for Tata to build up that particular project will also come under the operational creditor. Okay. So now this was all about the intercreditor agreement. And with this, we have completed the loan agreements also, the banking agreements also. If you guys now have any doubt, just put up. either regarding this class or any other class or any other loan any other type of agreement.